I will start with an example to help you understand the critical issue inside there with children. Like I said up front, welfare of the child is paramount. So once there are children that are under 18, they are considered minors according to the Majority Act of Trinidad and Tobago. And you cannot come to the court for a divorce where there are children and do not fill out what is called a statement of arrangements for children. You have to tell the court what are your plans for these children. Even if they live with the other spouse or they live with you or they live with grandparents, whatever. Once there are children that are under 18, you have to give the court some kind of indication as to your plans for their maintenance and their well-being. And very quickly, I'm dealing with a situation now where one person was married before and he had one child. The other person was not married and she had a child. And together they had 3 children. And all of those children are under 18. In the eyes of the court, there are 5 children of the family. We do not say children of the marriage. They are children of the family. Because in each instance, the children were living, kind of coming together from time to time. And the problem that arose here is that, without trying to spill the beans too much, one client was insisting that you pay for maintenance for my child that I had before I married you. And the other one is saying, but hey, you had that child so many years before I met you. Why should I pay maintenance for that child? And it is before the court now, and it's going all the way to trial. The point I want to make about that is, if I marry you with a 1-year-old baby or 6-month-old baby, and I stay in that union with you till 10, 11, 12 years or 5, 6 years, that child is a child of the family. And I would have accepted that child. I would have been assisting you to care for that child. It will not be so easy when the marriage is over for me to get out of continuing some degree of responsibility for that child. It's unfair, but it is fair.
Yes, true. And what if the other is true with your scenario there, when the child is considered a child of the family, but you would have met that child older? You had the child at 10 or 12. We got married when the child was 12. The child We got married for 2 years, and now I'm requesting maintenance.
Right. It's going to be tested in the court shortly, but my gut is that I was never part of this child's life for the first 10 years. You
Right.
were taking care of your son, your daughter, all
Please.
by yourself or with the help of other persons. Or you may have had a maintenance order in the court for the father. Now that I have been married to you for 2 to 3 years or even 5 years and the marriage is over, I do not see why I must continue to have responsibility for a child that I did not have responsibility for the first 6, 7, 8 years.
I want to
What
raise a point
happened
against
during
that,
that
but
time?
this is not court.
Huh?
I say I want to raise a point against that, but this is not court.
No, feel free. I want to hear you because it will give me more ammunition when I go to court.
So you are
This is going
for,
to trial.
right? And what if the other side could be able to prove that, but for your involvement with the child's life, now the child has grown accustomed to and has created a standard of living because of the marriage, and now it would
Uh-huh.
be unreasonable because of the divorce to now have to change that child's standard of living and
All right.
accessibility to certain things. For
I
instance,
like it.
private schooling.
I like your question, and it's a nice one. And here's my answer right away.
Mm,
One of the facts, when we look at, we're not doing that now, but when you look at it, how to put it nicely, All right. When you look at all of the things the court considers when we come to property settlement, one of the major elements in our legislation says the court has a duty to allow the party to return to the condition they would have been in had it not been for the divorce, if it were possible. So the court, so to say it differently, the court has a duty as far as it is possible to keep the parties in the condition they would have been in had it not been for the divorce. Generally, it is not possible to keep parties in the condition they would have been in were it not for the divorce, because one person now has to find a new source of rental income and has to buy new appliances, stove, fridge, etc., and start a whole new life. So generally, when parties divorce, your income, it's no longer joint income, and one income has to now go so much further. So in that particular case, yes, the children have a right to a standard of living, and I would be arguing the very best standard of living as best as can be afforded in the circumstances, and without necessarily involving my client. What was her standard of living before she met my client with a child that was 8 years
So
old?
I am not representing that side, so I have no interest in helping
So
them.
I appreciate to hear what you're saying, and thank you. All right,
No
there's another
problem.
question here. What happens if there's a maintenance order, then the party to whom the maintenance is paid gets remarried? Haha. Nice question. If the maintenance order is for the spouse, it stops on remarriage. If the maintenance order is for children, children will always remain children, whether or not the parties remarry. And so the children's welfare and well-being will continue regardless of the new estate of the person. So the
Yes.
maintenance payment ought to continue. However, like I said, if it was maintenance to the spouse, it ends on remarriage. So we have some very smart people. They never
Yes,
remarry.
I love that question from Mel because on the course website, they would have correctly indicated there that maintenance stops upon remarriage. However, a lot of people, when they ordinarily read that, they have misinterpreted what the court has put on their website, and they take it to mean that the maintenance for the children discontinues. But we have to remember in Trinidad and Tobago, we do not use the words as alimony and what's the American terms? Is
It's alimony, they like to say.
they use alimony for
Child
the
support.
child support, right? So I think that is the mix up for us in Trinidad a lot with our members of the public, because American TV and American culture differentiates the difference between the maintenance. They have alimony and child support. In Trinidad, we have maintenance, and so sometimes a bit difficult for them to notice, which we are speaking of. But if the court would have given you maintenance, a maintenance order applies to you as a spouse. If you remarry, you cannot continue getting that payment. However, if the maintenance is for the child will remain the child to that parent, regardless of if the other party remarries. So their obligation stays.